As it pleases the court, my lord, my ladies, I appear for Ms. Maughan together with my learned friend, Ms. Blizzard.
May it please the court, I appear for Mr. Downer with my learned friend, Ms. Raj.
So this is the court, my ladies and my lord. I appear for the respondent together with my learned friend, Mr. Masuku.
Between us, we've agreed that I'll start if that's in order with the court.
Before we start, the judge president has informed me that you have all agreed to specific time limits. And that's 45, and an hour and a half. Is that correct?
That's correct.
Please.
15 for reply.
I'd appreciate it if you could kindly stick to those.
As the court pleases. Lords and ladies, Lord and ladies, I'm going to deal with the following matters in my submissions. Firstly, I'm going to make submissions on what this case is not about. Then, secondly, I will make submissions about what this case is about. Thirdly, I will deal with Section 18(4) of the Superior Courts Act. Then, fourthly, I will deal with subsidiarity. Fifthly, I will deal with the affidavit of Mr. Hofmeyr. Sixthly, I will deal with reliance on this court's judgment. And finally, I'll say something about Stalingrad. So let me start with what this case is not about. We submit firstly that this case is not about whether Mr. Downer should be permitted to prosecute Mr. Zuma. In the answering affidavit, Mr. Zuma focuses overwhelmingly on that issue, why Mr. Downer is a bad person, why he is a bad prosecutor, and why he should not be allowed to prosecute him. And in the heads of argument, this theme is repeated at length. There's a repetition of the theme and a repetition of the abuse and the insults which are directed at Mr. Downer. We say there are three reasons why this case is not about whether Mr. Downer is a suitable prosecutor, this application. Firstly, that is a matter which is to be decided by His Lordship Mr. Justice Cleely, to be heard by him in a matter which will commence in 2 weeks' time. There's an application, as members of the court will know, what's called the second recusal application for the recusal of Mr. Downer. The main plank of the argument is that Mr. Downer is not a suitable person to prosecute, and so the matter is already before the court, before His Lordship Mr. Justice Cleely, and there's no conceivable reason why this court should attempt to decide that matter now. Secondly, the reason Mr. Zuma gives as to why Mr. Downer shouldn't be allowed to prosecute him is that he shouldn't be prosecuted by somebody who is himself facing a criminal prosecution. He says that's a bad thing, but I shouldn't have to be prosecuted by somebody who is himself being prosecuted. But that misses the point with respect that is going to happen whatever this court decides in this application. Because whether or not this court grants a Section 18(3) order, Mr. Zuma will be prosecuted by a prosecutor who is facing criminal prosecution, unless Justice Cleely decides otherwise. The only difference is about when that private prosecution will start. Either when the prosecution of Mr. Zuma commences, the prosecution of Mr. Downer will already have started or be proceeding, or it will be standing over until after the appeal is decided. Any appeal process is decided. But either way, there will be a prosecutor there, Mr. Downer, who is facing criminal prosecution. So it doesn't solve Mr. Zuma's problem to get Mr. Downer to say, no, well, there shouldn't be a Section 18(3) order. Whether or not there's a Section 18(3) order he will be faced by a prosecutor who is himself facing the private prosecution. So the issue before this court, we submit, is not whether Mr. Zuma should be prosecuted by a person who is facing criminal prosecution, because unless His Lordship Justice Cleely decides otherwise, we know as a fact that Mr. Zuma will be prosecuted by a person who is facing criminal prosecution. So the complaint that Mr. Zuma doesn't want to be prosecuted by a person who's being prosecuted doesn't, with respect, assist the court at all. And that's the second reason why this question is not an issue in this case. The third reason why it's not an issue in this case is that Mr. Zuma's obsession about removing Mr. Downer betrays the truth about what the private prosecution itself is about. The private prosecution itself is an attempt to remove Mr. Downer as the prosecutor. And that's one of its goals. There are others. And that's what makes the private prosecution unlawful, because it's for an ulterior purpose. Members of the court know all about that. I don't have to address that. The court knows, the authorities in that regard, that a prosecution for an ulterior purpose is an abuse of the process of court. It's unlawful, and it will be set aside by a court on application. And I'll come back to the question of the authorities in that regard a bit later. So that's the first matter. So the first matter that this case is not about is about whether Mr. Downer should be permitted to prosecute Mr. Zuma. That's not, with respect, an issue before this court. The second issue that it's not about is about whether Mr. Zuma is entitled to attempt to appeal against the judgment of this court delivered a couple of months ago. And we say, of course, Mr. Zuma has that entitlement. It's never been disputed, and it's not disputed. We do say that Mr. Zuma's right to apply for leave to appeal will be used by him to advance Mr. Zuma's strategy of delay. But that's another matter. That doesn't mean that he doesn't have the right to seek leave to appeal. And if he fails here, to seek leave to appeal to the SCA, and if he fails there, to seek leave to appeal to the Constitutional Court, he is entitled to do that. There's not a dispute. So the question then, that brings me to the second main topic, which is what this case is about. And we say the question is, in fact, a simple one. It is whether, while Mr. Zuma is attempting to appeal, he should be entitled to proceed with a private prosecution. The question is therefore whether, in the interim, the private prosecution should stand over while an attempt is made, or attempts are made, to appeal, or whether the private prosecution should continue, notwithstanding this court's judgment handed down a short while ago. And so the case is solely about what the interim arrangements should be while the appeal processes are followed and unfold. And that's, with respect to a somewhat narrow issue, a narrower issue than the issues which are canvassed in the papers. That brings me then to my third topic, which is Section 18(4) of the Superior Courts Act, because it is that section which tells us what the test is, and there are 4 tests. The first test is whether there are exceptional circumstances in this case. And we deal with that in our heads of argument from paragraph 52.1 to paragraph 52.7. And can I just take the court there? It's page 16 of our heads of argument. We make the submission, page 16, paragraph 52, that there are multiple facts and circumstances which render this case exceptional and certainly out of the ordinary. They include the following. Firstly, the private prosecution was instituted in bad faith and with ulterior motives, namely to further delay the prosecution, to obstruct Mr. Downer in the performance of his duties, and Mr. Zuma hopes to have Mr. Downer removed as prosecutor. Secondly, the private prosecution is without any foundation in either fact, because Mr. Downer wasn't responsible for the disclosure of the doctor's report and there was no breach of privacy, and also no foundation in law, because no cognizable offence has been committed, even if all of the facts alleged by Mr. Zuma are true. So the case is, with respect, truly hopeless. Thirdly, allowing Mr. Zuma to continue with the private prosecution while he attempts to appeal against the decision of the full bench will perpetuate the harm caused by the abuse of legal process. In the words of His Lordship Mr. Justice Sutherland, which I'll come back to in a moment, it will put Mr. Downer in the predicament of being left with no relief, regardless of the outcome of the attempt to appeal, and he will suffer the forfeiture of substantive relief because of the inevitable procedural delays in getting the matter decided. Fourthly, we say that make the submission that this private prosecution is possibly unique in our law. I've certainly never heard of anything like it, and I've not seen anything which suggests that it's ever happened before in our law. It's a case of the accused attempting to retaliate and turn the tables by instituting a private prosecution against the person who is prosecuting him on behalf of the state. If this sort of conduct is permitted to continue, notwithstanding a fully and extensively reasoned judgment of a full court of this court, it will be an invitation to other well-resourced accused persons to engage in the same gambit. The administration of justice will suffer not only in this case but also in other cases. We will have endless private prosecutions instituted, certificates nolle prosequi issued, and meritless and abusive public prosecutions then launched for ulterior purposes and to slow down and delay and obstruct the prosecution. Fifthly, the private prosecution is part of an extended Stalingrad strategy which has obstructed and delayed the course of justice that was designed and implemented for this very purpose. Sixthly, the private prosecution is a mechanism which Mr. Zuma now attempts to use to punish people whom he perceives as his opponents. Mr. Downer, Ms. Maughan, and most recently the President. Two full courts, one in KwaZulu-Natal and one in Gauteng, have said this is an abuse and cannot be countenanced. Mr. Zuma should not be permitted to obtain the continued benefit of this abusive and unlawful strategy on the basis that he is attempting to appeal. And finally, Mr. Zuma has failed to make any effective answer to the assertion that he's engaging in a pre-announced Stalingrad strategy of delay and obstruction. And the application for leave to appeal and further applications which will follow if it's unsuccessful are part of that strategy. Now those, my lady and my lord, make this an extremely unusual case. It is an exceptional case on the facts, it is an exceptional case on the law, and it is an exceptional case in terms of the public interest and public impact of what is going on here. It is exceptional on all possible grounds, and it ought to be, we submit, dealt with as such. We then, in paragraph 47, we quoted with what Justice Sutherland said, His Lordship Mr. Justice Sutherland said. Paragraph 47, he explained the principle that the determination of whether the circumstances are exceptional must have regard to the actual predicament in which the litigant finds itself. He said, I quote, "In my view, the predicament of being left with no relief, regardless of the outcome of an appeal, constitutes exceptional circumstances which warrant a consideration of putting the order into operation. The forfeiture of substantive relief because of procedural delays, even if not protracted in bad faith by a litigant, ought to be sufficient to cross the threshold of exceptional circumstances." An example given is that of Bauer in this division. In Bauer, the court found that although it had granted leave to appeal, it was conscious of the undesirable outcome that relief granted by the court becomes a vacuous gesture, and so it granted leave to execute in terms of section 18.3. If leave to execute in terms of section 18.3 is not granted, the order which this court has made will become empty and vacuous because it will have no impact, and Mr. Downer will not get the relief which the court has held he is entitled to. So for all of those reasons, we say that if the private prosecutions continues while the appeal processes are delayed, while the appeal processes are followed, the relief granted by this court will become a vacuous or empty gesture. And so the test for exceptional circumstances you submit is amply demonstrated. The second test is whether the applicant will suffer irreparable harm if implementation is not ordered. We say that in this case, the private prosecution being continued in the interim will have the following consequences for Mr. Dana personally. He'll have to forfeit his personal freedom by being required to attend court. It's well established in the court and the authorities that is a substantial prejudice. He will have to possibly go through an extended trial on charges which are simply baseless. Mr. Zuma will be able to pursue his goal of what we say is an attempt to humiliate the person who's prosecuting him on behalf of the state. Mr. Dana also speaks for the prosecution on behalf of the state and the public. Mr. Zuma's prosecution will be delayed. The prejudice is that Mr. Zuma's prosecution will be delayed and obstructed by a parallel case taking place while the prosecution is running. And this is, of course, the very purpose of the private prosecution. And we say Mr. Dana, the state, and the administration of justice will suffer irreparable harm if this gambit is allowed to be executed and the prosecution continues unabated. Then the question whether the respondent will suffer harm if implementation is ordered. The only harm Mr. Zuma can point to is the alleged harm caused by his being prosecuted by someone who is himself facing a criminal charge. As I've already submitted, that will happen whatever this court decides in this application. Because unless clearly J decides otherwise, Mr. Zuma will be prosecuted by a person who's himself facing criminal prosecution. The only difference is when his prosecutor's criminal prosecution is started. When his private prosecution is started. And we say Mr. Zuma has been unable to show any prejudice which will be caused by an interim implementation order of the court of maintenance court. It's true that the onus is on Mr. Dana in this regard, and Mr. Dana says there will be no prejudice to Mr. Zuma. It's then for Mr. Zuma to say what prejudice there will be to him. And he has the duty to provide evidence of it. It's what one can call an evidentiary burden or a duty. He has failed to do this because he failed to put up any evidence that there will be any prejudice that he will suffer, and we say it will make no difference to Mr. Zuma's position if the private prosecution starts now or if it starts after the appeal processes, if they're successful. Of course, if the appeal processes are unsuccessful, then the prosecution will never start. So we say there are only two possible advantages to Mr. Zuma from the private prosecution starting now. First, it's likely to delay and obstruct his own trial, but that's an impermissible consideration. Secondly, it may assist Mr. Zuma to complain and build up a bit of steam in his attempt to get rid of Mr. Dana, but that too is an impermissible and ulterior purpose. So that then brings me to the fourth consideration, which is the prospects of success. And we make the submission that the intended appeal has no material prospect of success. This court, of course, has yet to decide the application for leave to appeal. And we recognize that the court will not want to prejudge, in this case, whether there is a reasonable prospect of success. But we submit that what the court can and should say at this stage is the following. That the court makes only a prima facie finding at this stage, subject to full argument which is going to be advanced in the application for leave to appeal. And that whatever the prospects may be, it can already be said that they are not strong. Whether they're strong enough to justify granting a leave to appeal is a matter which this court will decide in the application for leave to appeal. Because the test is not that they must be, in that case, is not that they must be strong. We say that the court is already able to say that prospects of success, prima facie, do not look strong. So to summarize, Mr. Dana seeks an interim order. He doesn't ask for an order that Mr. Zuma may not prosecute him. All he asks is that a private prosecution should not start unless and until an appeal court has overturned the decision of this court. The appeal court will decide if it is granted whether the prosecution can proceed at all. All Mr. Dana seeks is to regulate the process of the interim. So it's not just about the next appearance, which is Friday next week, the 4th of August. It's also about further appearances, and it's also, of course, about the trial itself, because Mr. Zuma wants to run the trial, he wants to run the private prosecution in the face of the judgment of this court. And so I now want to turn to questions of prospects of success. And I'll deal first with the question of subsidiarity. Subsidiarity is the main focus of Mr. Zuma's submissions on prospects of success. What he calls subsidiarity accounts for about 25% of his heads of argument in this application. We should remind ourselves what the doctrine of subsidiarity is. The doctrine is this: it's where the Constitution confers a right, and a statute has been enacted to give effect to that right, then an attempt to enforce the right must be brought under the statute and not directly under the Constitution. So it's where the Constitution confers a right, and there has been a statute which is enacted to give effect to the right. When you look more closely at Mr. Zuma's subsidiarity arguments, you see that they're actually, what they are really about is about whether a so-called civil court can hear this allegedly criminal matter. That's what the subsidiary argument is. And can I read to the court what was said by Mr. Zuma's counsel in paragraph 21 of their heads in the previous hearing, because they put their finger on it. They say of Mr. Dana and Mr. Maughan, they have, however, chosen the forum of a civil court without pointing out any legal basis for avoiding the criminal court and process. This is the classical abuse of court process. A civil court cannot deal with the merits of the charges and do so without any complaint that the criminal procedure is unconstitutional. That is the essence of the subsidiarity principle. So the subsidiarity complaint is all about the civil criminal complaint. Now, Mr. Dana and Mr. Zuma and those who are advising him must know that there is overwhelming authority, that the proper way to deal with the alleged abuse of process through a private prosecution is to bring an application in the motion court for the prosecution to be set aside. So what Mr. Zuma attempts to do is to call this not a question of the right court under the common law. He attempts to call this a question of subsidiarity, to try to, as it were, sex it up, to make it different from a case about 70 years of authority, starting with the Solomon case in 1950, but to make it a case about subsidiarity under the Constitution. But whatever you label you give it, what this remains is a claim about the alleged differences between so-called civil and criminal courts, and about where the allegedly abusive court, where the allegedly abusive private prosecution can be challenged. That was fully addressed by this court in its judgment. The court addressed the question of whether a civil court has the power to deal with this matter. And when Mr. Zuma says, well, the court didn't deal with subsidiarity, and that's a ground of appeal. But the complaint that the court didn't deal with subsidiarity is just playing with words. It is empty. Because the court did deal with the substance of the issue, namely whether an application of this kind can be brought in this court. So if a court of appeal, if somehow a court of appeal concludes that this court should have addressed subsidiarity in those words, and that therefore the court erred, what that amounts to at best is a ground for leave to appeal, to say, oh well, we didn't deal with it, we'll have to refer it to the SCA. And the Court of Appeal will then, of course, itself deal with the matter. But that doesn't bear at all on the question of on the prospects of success in an appeal. The subsidiarity argument will fail because it doesn't take matters any further because it doesn't provide any prospect of success. There's no prospect of success that the subsidiary argument is a good argument. And so if there was a failure by the court to deal with it, it doesn't bear on prospects of success. It only deals with the question of whether the matter should be referred to an appeal court. So the subsidiary argument does not provide any basis for claiming that this court failed to do its job and that there are therefore prospects of success in the appeal itself. As to the merits of the subsidiarity argument, I've stated the principle. It's about a case where the Constitution confers a right and the statute then gives effect to that by setting out the nature of the right. So the first question is, what is the right which is conferred by the Constitution, which Mr. Downer is seeking to enforce in this case? What is the right, constitutional right on which Mr. Downer relies? Mr. Zuma says here Mr. Downer relies on the Section 34 right of the Constitution and the right of access to courts. There's no mention of Section 34. This is not a case about Section 34. Mr. Downer is not relying on the Section 34 right, and he's not relying on any right conferred by the Constitution. What he's relying on is the well-established common law principle that which entitles him to enforce the protection which the common law gives him against the abuse of process. The common law confers a right to go to court against the abuse of process, and that is what Mr. Downer is seeking to do. He's not seeking to enforce any constitutional right at all. The Constitution doesn't speak about that issue, and Mr. Downer is not attempting to enforce a right conferred by the Constitution. So the subsidiary argument falls at the first hurdle because there is no constitutional right which Mr. Downer is attempting to enforce. But if there is somehow a constitutional right which he's attempting to enforce, then the question is, what is the statute which has been enacted in order to give effect to that constitutional right? And here what Mr. Zuma says is that the right is the statutory provision which is relevant is Section 14(1)(a) and Section 14(2) of the Superior Act. That he says is the statutory provision which was enacted to give effect to Mr. Downer's constitutional rights which he's seeking to enforce. So we look at Section 14(1). Firstly, we look at Chapter 4 of the Act, because Section 14 is part of Chapter 4. Chapter 4 is headed the manner of arriving at decisions by superior courts. So what Section 14 is about the manner of arriving at decisions by superior courts. Then we turn to Section 14 itself, and it tells you, again in terms, Section 14 is about, in the words of the heading to the section, manner of arriving at decisions by divisions. So Section 14, that's what Section 14 is about. It's not about giving effect to constitutional rights. It's about saying how many judges there must be for different sorts of cases, who may sit, who may not sit, and so on. 14(1)(a) deals with single judges sitting as a court of first instance, and that the JP can determine that a matter be heard by a court consisting of not more than 3 judges. Section 14(2) says that a criminal case, a court must be constituted in the manner prescribed in the applicable law relating to procedure in criminal matters. None of that has anything to do with enforcing, with giving effect to any constitutional right. It's just about the mechanics of the administration of justice, how many judges will sit in different cases. And so it can't be the Superior Courts Act which gives effect to the alleged constitutional right Mr. Downer is pursuing, because that Section 14 and that Act don't deal with any statutes. They just deal with who sits in which case. And then secondly, in a remarkable submission, Mr. Zuma says, well, actually there are 2 statutes which give effect to the rights conferred by the Constitution. One is the Superior Courts Act, the other is the Criminal Procedure Act. Well, the Criminal Procedure Act was enacted in 1977. It can hardly have been enacted to give effect to the rights conferred by the 1996 Constitution. That is rewriting history in the most extraordinary fashion. So we say that there is no constitutional right which Mr. Downer is seeking to enforce, and in any event, Section 14 of the Superior Courts Act does not give effect to any constitutional right. There's no statute here which deals with whatever the alleged constitutional right is. So we say the result is that subsidiarity doesn't arise. It can't arise at all. It's irrelevant. The truth is that this is a complaint about which court should have heard the application, and that I've addressed already. So that brings me then to the question of the authorities, and I'm not going to take the court through all of the authorities. We referred to them, we dealt with them, our heads of argument in the last hearing. I simply make this submission, that it is since the Solomon case in 1950, and from the Solomon case in 1950 to the Ramaphosa cases in 2022 and 2023, that's now for 73 years, the courts have consistently said that you can make an application to court for an order stopping a private prosecution which is an abusive process. The way to deal with it is you apply to court and you say, please set aside this process which is an abusive process. It has been part of our law now for 73 years. It is dealt with in pre-constitutional cases, and the same is dealt with in the constitutional era. Case after case, I haven't counted them. I think there are about 12 of them, in which the courts have said, if the private prosecution is instituted, and if it's alleged to be an abusive process, you apply to court to stop the process, to set aside the prosecution, and that's never been questioned anywhere. So that's the law, and that's what Mr. Downer has done. So the second thing I say about this is that in any event, what Mr. Zuma calls a civil court is the only court that's empowered to deal with this abusive process. There's nothing in the Criminal Procedure Act which enables an accused person to stand up before the case starts and say, I object to being subjected to this criminal process, this prosecution process, because this is an abuse. There's nothing in the Criminal Procedure Act which makes any provision for it. The closest you get to it is Section 106(1)H, the special plea, but Justice Kuhn has explained that that doesn't apply to, it's not a broad application of general complaints about the prosecution. It's very specific about title to prosecute. And so, how would, assume Mr. Downer arrives at the criminal court, which is being prosecuted, and he wants to object to the prosecution taking place at all because it's an abuse. How does he raise it? And how does that court deal with it? Well, he can't raise it, and that court can't deal with it. These issues can't be raised as liminal issues, if I can call them that, before the prosecutions commence. They are not covered by a lack of title to prosecute, and they are not covered by Section 174. What Section 174 says, well, you can sit through your trial, and when you get to the end of the state case, you can apply for a discharge. But two things about that. Firstly, you've got to sit through the case, so you've got to submit yourself to prosecution, which you say is unlawful. Secondly, of course, Section 174 is not about abusive process. It's not about any of those things. It's simply about whether there's a case to answer. And Section 174 provides no remedy for a person who says, as Mr. Solomon says, and as Mr. Ramaphosa said, and as umpteen people in between said, I object to this prosecution because this is an abusive process, and I shouldn't be put through having to stand a criminal trial. And so there is the point is that Mr. Downer is not asking for an acquittal. Learned friends keep on saying, no, your lordship and your ladyships gave him an acquittal. He's not asking for an acquittal. He's asking for if he wanted an acquittal, he would go to the criminal court, stand his trial, and defend himself. He's saying that trial should not happen at all because it's an abusive process. And the only remedy is that the courts, as the courts have recognized again and again and again, is you apply to a motion court for an order stopping the abuse. In this context, I do want to refer to, our learned friends rely on what was said by His Lordship Mr. Justice Wallace in the Moyo case, they refer to it at it's at page 27 of the heads of argument, and the top of the page, page 27, and they quote what His Lordship Mr. Justice Wallace said. He said, "The appellants do not seek to impugn the provisions of the Criminal Procedure Act in any way. Yet, they are seeking to assert their fair trial rights before the civil court." And underline that, they are seeking to assert their fair trial rights before a civil court. That should give pause for thought. Why are issues germane only in the context of civil criminal proceedings, namely fair trial rights, be encompassed and determined in civil proceedings and not in the constitutionally compliant forum and in accordance with the constitutionally compliant statute provided for the adjudication of criminal cases? What it was about fair trial rights. And we know what the fair trial rights are. It's the right to legal representation, it deals with the admissibility of evidence, it deals with the presumption of innocence, all of those things which are set out in section 35 of the Constitution. And those are matters which must be raised in the court which is hearing the criminal trial. If you complain your trial is unfair, you complain to the criminal court, and if you don't get satisfaction there, you appeal against the judgment of the criminal court. You can't rush off to motion court and ask for an order that a certain witness's evidence is inadmissible, or ask for an order saying that the reverse onus is inadmissible. And Mr. Moyo's case exemplifies this. His complaint was of allegedly unconstitutional onus. Now, I should say that there still remains controversy about whether you can go straight to the civil courts to challenge the validity of a statute, even a statute of that kind. And one doesn't need to go into this. What the point of the matter is that the judgment of His Lordship Mr. Justice Wallace was about fair trial rights. If your complaint is you haven't got a fair trial, you raise that in the criminal court. You don't rush off to the civil court. That in principle must, with respect, be correct. But we say that could hardly be, this case could hardly be more different. It's about something which cannot be addressed by the criminal court. It's not a matter of fair trial processes, of fair trial rights. And the courts have repeatedly said, you bring that challenge, you bring an application or a motion. This case addresses a complaint. There should not be a prosecution at all. That belongs in the motion court. Then that brings me to the fifth topic which I want to address. And that is Mr. Dana and Mr. Hoffman and the spy tapes case. Mr. Zuma bases a large part of his complaints about Mr. Dana's conduct, alleging dishonesty, alleging malfeasance of various kinds, arising from the affidavit of Mr. Hoffman in the spy tapes case. We make three submissions in this regard. The first thing is to note what has happened, what Mr. Zuma has done. He has simply filed 144 pages of Mr. Hoffman's affidavit in that case as an attachment to his answering affidavit. He doesn't specify the passages on which he relies. He doesn't identify what Mr. Dana is alleged to have done, which is supposedly borne out by these passages. He simply throws 144 pages at the court and at his opponents, and he says, you must trawl through these documents and find out what is relevant and why it is relevant. Now, you can't conduct litigation in that manner. It's been said by the courts again and again. It's been said in the high courts, in the SCA, and in the Constitutional Court. If you file an attachment on which you're going to rely, you have to say, this is the part of the attachment on which I rely, and this is why it is relevant. And the leading case on this issue is a case called Swissborough, Swissborough, Swissborough Diamond Mines versus Government of the RSA. The reference is 1999 2SA 279, 1999 2SA 279T at 323I to 324F. And it's with respect to trite proposition in litigation. It's been that judgment has been followed, as I say, by the High Courts, by the SCA and the Constitutional Court in umpteen cases. And so actually the whole of Mr. Hoffman's affidavit falls to be struck out. It's not properly before the court because it can't be relied upon. We don't make anything of that. We say, secondly, if you actually read through those 144 pages, which is an exhausting business, you will see that two things are clear from it, from Mr. Hofmeier's affidavit. Firstly, Mr. Dana was not involved in the shenanigans to which Mr. Hofmeier refers. You know, the decision to withdraw the case, or decision to postpone the case for political reasons, all of those questions, those had nothing to do with Mr. Dana. And it's not alleged that they had anything to do with Mr. Dana. That was taken by senior people in the criminal justice system. The second thing that is clear is that Mr. Dana's superiors were well aware of those shenanigans. Some of them were involved in the shenanigans. So there was no duty or no reason for Mr. Dana to report to them what they already knew and what some of them had already been involved in. So it actually has nothing to do with Mr. Dana as far as this case is concerned. It's true that Mr. Dana made an affidavit. He made an affidavit disagreeing with saying that he disagreed with the decision to stop the prosecution. And he explained what the NDPP said to him. But there's no suggestion that he was involved in the shenanigans, and it's clear that the people, his superiors, knew about the shenanigans, some were involved in them. So why that affidavit of Mr. Hofmeier has anything to do with this case is difficult to understand. It's just thrown in for the hope that somehow the mud will stick and that the court will say, oh well, this doesn't look good, and Mr. Dana somehow was involved in this message. The matter was dealt with by His Lordship Mr. Justice Quinn in the section 106(1)H case. And this is what His Lordship Mr. Justice Quinn says at paragraph 215. Mr. Zuma had said that Mr. Dana was an essential witness in the spy tapes case. This is what His Lordship Mr. Justice Quinn said. He says, this paragraph 215, Mr. Dana was not an essential witness in the spy tapes case. He did not submit his affidavit in support of the DA. His affidavit was provided at the request of Mr. Hofmeier after he, Mr. Dana, had refused to make an affidavit, simply confirming the contents of Mr. Hofmeier's affidavit. Mr. Dana's affidavit disagreed with the decision of Messrs. Msher, Hofmeier, and senior leadership of the NPA, who had sought to defend Mr. Msher's decision to discontinue the prosecution. Thank you. Mr. Dana's, my learned friend has said, I need a couple of extra minutes, I can have some of his. I'm covering ground which he would otherwise have to cover. Not just because of family relationships, he is indebted to me. His Lordship continued. Mr. Dana's finalized affidavit was filed by the State Attorney, which was representing the NPA on the 11th of June 2015. These are matters of public record about which there is no dispute. Mr. Dana's independence of mind speaks for itself, and his stance was ultimately vindicated by the judgment in the spy tapes matter by the SCA. So why we are burdened with all of the stuff about Mr. 140 pages of Mr. Hofmeier is not difficult to understand. Then, secondly, so that brings me to the sixth topic, reliance on this court's judgment. Mr. Zuma criticizes the reliance which is based on this court's judgment. We say that's not well founded. That is a judgment of three judges of this court. It would be absurd to close one's eyes to it. We're entitled to rely on it, and the court is entitled to rely on it, unless it's demonstrated that the judgment is incorrect in the matter on which reliance is placed. But otherwise, it's a judgment, and a judgment stands. Of course, the court will bear in mind that the would-be appellant disputes some of the findings, but to suggest that the court will treat its own judgment as pro non scripta merely because an application for leave to appeal is being lodged is with respect absurd. And that brings me to the final subject of Stalingrad. I've deliberately not spoken about Stalingrad because it causes great agitation on the other side. I'll say only this. One, Mr. Zuma's counsel said that he would follow the Stalingrad script. Two, Mr. Zuma has never challenged or disputed the correctness of that statement. that he decided to follow the Stalingrad strategy. 3, the Stalingrad strategy involves a process of serial delays, with these serial objections, pursuing appeals, and through the hierarchy of courts, and then when that objection fails, starting off on the next objection. And that is actually what has happened in this case. Mr. Zuma now says in this case that that is not what his counsel ever meant, what his counsel meant when he referred to the Stalingrad strategy. But he doesn't tell the court what his counsel and he actually meant, what they did mean when they said he was going to follow the Stalingrad strategy. We say that Mr. Zuma's actions speak for themselves. The question is not, and I need to emphasize this in the light of the heads of argument on the other side, the question is not whether every delay has been taken from Mr. Zuma. The question is rather whether he has repeatedly and consistently brought about delays through challenges which are without merit and which the courts have repeatedly held are without merit, which have the result that he's found his trial has not yet started. The question is whether he has repeatedly and consistently brought about delays through challenges which the courts have held are without merit, with the result that his trial has still not started. We submitted that is a fact that he has done this. It's a fact that can't be disputed, and there's no room for any argument or about that. Whether you give it a label of Stalingrad or not is with respect simply irrelevant. The Lord, that's 27 minutes, 26 minutes. And those are my suggestions. Thank you.
Thank you. Thank you, my lord and my ladies. I know it was only a minute that I gave my learned friend, but dinner is on him tonight, so it's fine. My lords and my ladies, the reason that I indicated that I wouldn't need as much time as my learned friend is because he has indeed very helpfully covered much of the ground which I would have intended to cover. And I will not repeat that. And I hope to be done in less than the 45 minutes, but let's see how we go. My lords and my lord and my ladies, I wish to begin in the same point as my learned friend for Mr. Downer did, and that is talk about what is the relief sought and what this case is about and what it's not about, because I'm afraid that what you have before you is an extraordinary throwing up of dust in a manner that obscures the real issues. And really, I can't do better than refer to our heads of argument at paragraphs 11.3 to 11.4, where we have set out what is not at issue before you. And we say there that Ms. Maughan does not ask this court to grant orders regulating criminal proceedings against her that would bind the presiding judge in the criminal trial, should it proceed. The relief Ms. Maughan seeks is simply the immediate enforcement, and I will say, emphasize, the immediate interim enforcement of the full court's order, which set aside the summons which Mr. Zuma issued. Now that relief, and I'll come back to the interim nature of it, that relief would render the criminal proceedings against Ms. Maughan a nullity, because what that means is that the summons has been set aside and there can be no criminal proceedings. And here's the point about interim: unless and until this court's order in the main case is set aside on appeal. So I know my learned friend for Mr. Downer has said it, but I need to say it again. Let us assume that a Section 18.3 order is granted, as it should be. Then there is one of two worlds. What it means is that the criminal proceedings against Ms. Maughan will not proceed at the moment, because the summons would have been set aside, execution would have been granted on an interim basis. One day, probably at some distant point in the future, given the way litigation has taken place by Mr. Zuma and his team, one day, finality will be reached on the main case, the merits judgment. And either Mr. Zuma will win or he will lose. If he wins, then this court's 18.3 order will fall away because it's an interim order, and the prosecution can resume, and Ms. Maughan can appear, and Mr. Zuma can appear, and everything will take its ordinary course. That's the one world. The alternative world, and the world that we say is virtually a racing certainty, is that Mr. Zuma will lose. And in that case, there's no prejudice to him at all, because, of course, this court's judgment was correct. So we are not debating a permanent interdict against prosecution today. We are not debating a permanent anything. We are debating whether this court should grant a Section 18(3) order, which is by definition interim. It lasts only for so long as there are appeals or applications for leave to appeal. And if Mr. Zuma is right, and at the end of the day this court got it hopelessly wrong and its judgment is set aside, then his rights are fully protected. And Ms. Maughan will have to face the music, and there will be a trial, and so be it. And the reason that's important is because it comes to the question of irreparable harm to Mr. Zuma, and I'm going to focus there. Because we know that Section 18(3) is a debate about irreparable harm, and my point that I want to highlight now but come back to is there is no conceivable harm to Mr. Zuma by virtue of this order. And we say, and we said it in our heads, and I say it again, can Mr. Zuma and his counsel seriously say to this court with a straight face that they want to proceed with prosecuting Ms. Maughan in the face of this court's judgment before it has been set aside on appeal? Now my submission is that no one can say that with a straight face. And yet they have to say that with a straight face if they are to resist the Section 18(3) order. They have to say that when it comes back, what they will want is not a mere postponement, but they will want the trial to proceed. But they can't say that. But once they can't say that, there is no prejudice. So, just to return to the heads, the relief that we seek is simply the immediate enforcement of the full court's order on an interim basis, which set aside the summons. That would render the criminal proceedings a nullity immediately, unless and until Mr. Zuma succeeds in setting aside the full court order, that's the main order, on appeal. In these circumstances, there can be no question of this court regulating the criminal proceedings or fettering another judge's power to regulate criminal proceedings, because there will be no valid criminal trial at all. If this court's order stands, or if it is enforced on an interim basis, there is no criminal trial because there is no valid summons. And so lastly, and at 11.4, as a preliminary matter, we make the point that if the court grants interim execution of the full court's order, Mr. Zuma will not be required to continue running his criminal trial without the appearance of the accused. Now, that's the argument that you keep getting given. But if you grant this order, Mr. Zuma will have to run his criminal trial without the accused? Of course not. There will be no criminal trial to run. If there's no valid and extant private prosecution, there would be no cause for the criminal court to convene at all, and Mr. Zuma would have no trial to run. In the event that Mr. Zuma's appeal is successful, he will be entitled to pursue his prosecution in the ordinary course. Now, those two paragraphs with respect are the heart of the case, because when you understand the correct question, the answer is, in our respectful submission, blindingly obvious. There is no harm to Mr. Zuma by granting a Section 18(3) order, and as I will come to, there is palpable harm to Ms. Maughan if you don't grant a Section 18(3) order. So, against the backdrop of what the relief is sought and the true nature of the case, could I turn to deal with 4 topics? The first will be exceptional circumstances. The second will be harm to Ms. Maughan. The third will be harm to Mr. Zuma. And the fourth will be prospects of success. And then in conclusion, I'll say a word on urgency, and it's only one word because it is so obvious with respect. But let me begin with exceptional circumstances, because what Section 18 has done is it has made this an exceptional circumstances test. We've got to show exceptional circumstances. And we agree with respect with everything that's been submitted on behalf of Mr. Downer on that score, and that really should amply satisfy it. But can I put it more simply? We are dealing here firstly with a private prosecution. That is exceptional. Happens very rarely. We know that now. Secondly, we are dealing with a private prosecution of a journalist for doing her job. That is, as far as we can tell, unprecedented in our law. Certainly no one has put up any such case. Thirdly, we're not just dealing with a private prosecution and not just a private prosecution of a journalist. We're dealing with a private prosecution of a journalist by a former president. And you will recall the submissions we made last time and that were made by the amici about the duties of the former president. But it's a private prosecution of a journalist by a former president. No one has pointed to any example of that occurring in our country's history or indeed anywhere else in the world. But fourthly, we are dealing with a private prosecution of a journalist by a former president, which has been held by a full bench to be an abuse. Now, are we really still debating whether this is an exceptional case? With respect. It is patently an exceptional case. If you just start those four facts: a private prosecution of a journalist by a former president, which has been held to be an abuse. That by itself renders the case exceptional. We're not dealing with your ordinary crash bash, your ordinary civil claim, even your ordinary constitutional challenge. We're dealing with something that is so unusual that it's palpably an exceptional circumstance. And that is without even getting into the harm. And of course, we know from the jurisprudence that the harm can count both for harm and for exceptional circumstances. But we submit with great respect, this is obviously an exceptional case. And it would be surprising to hear otherwise, although I suspect we will hear otherwise. So now I turn to the second topic. Once the first box is ticked and it's an exceptional case, the question is, has Ms. Maughan shown, on a balance of probabilities, that's the test, that she will suffer irreparable harm if an 18.3 order is not granted? Now, we have dealt with that in our heads of argument in some detail. I will not read the heads, but I will use them as a structure. And we deal with that at page 14 of our heads. And you will see that we specify 4 forms of irreparable harm. And remember, with respect, if I may say, we're not dealing here with whether criminal prosecution, private prosecution in general is a good idea. We're not dealing with whether it should be interdicted at all. We are dealing with a narrow question. Should it be allowed to proceed in circumstances where this court's order, its main order, has not yet been set aside by a court on appeal? That is the question. Should the trial of Ms. Maughan and her duty to appear be allowed to proceed in circumstances where 2 things have happened? This court has found that it's an abuse and unlawful, and no other court has set that aside yet. That's the point. So we deal with 4. The first one we speak about is the rights to freedom of movement and personal liberty. And we make the point that Ms. Maughan will be obliged to attend at criminal court against her will in order to comply with Mr. Zuma's unlawful summons. She will be required to attend on the 4th of August. She will be required to attend beyond that. Because last time we had a debate, the time we got postponed for August, there was debate about could you postpone sine die, couldn't you? And the other side's position was you can't postpone sine die. It's got to be one appearance after the next because that's the way the criminal system works. Well, fair enough. But what that means is it's the 4th of August and the next appearance and the next appearance and the trial. Because if they're not planning to run the trial now, then what is all this kerfuffle about? Why don't they just agree? Now, our learned friend's answer to that is to say, well, there's no problem because she's out on bail. But that very point is answered by the very authority we put up, not in our heads, but in our replying affidavit. And that is the judgment of the SCA in S versus Western Areas. It's referred to in the replying affidavit, but let me give you the reference. It's S versus Western Areas, 2005, volume 5 of the South African Law Reports, page 214, at paragraph 1. And what Justice Howie said there for a unanimous court was, a criminal trial cuts across a number of an accused person's fundamental rights. Attendance at the trial, even if on bail, limits freedom of movement, and even the right to liberty is curbed to an extent. That is binding authority, it is from the SCA, and it is unequivocal. So the question is this: does it constitute irreparable harm to Ms. Maughan to be required to attend on pain of criminal prosecution in court to face charges which have been held to be unlawful and an abuse, even while that decision has not been set aside? It's obviously irreparable harm. It's patently obvious with respect. And the suggestion by our learned friends that, or by Mr. Zuma, that Ms. Maughan has already suffered harm because she appeared previously, and so there can be no further damage, that's the suggestion made in the answering affidavit, is really without any merit. On the contrary, further appearances in the criminal court are patently harmful, because she will have to appear again and again and be subjected to rounds of abuse on social media every time that happens. So, the first point, that first form of irreparable harm, is plainly established. The second form of irreparable harm is about Ms. Maughan's personal safety and security, because Judge Howie was not speaking about attendance at a criminal trial in a context of the kind of media circus and social media circus which has been unleashed on Ms. Maughan. He was talking, the Western Areas case was about the Kebbles, and there was nothing of the sort. He was saying just having to arrive limits your rights. Just having to arrive limits your rights. But Ms. Maughan doesn't just have to arrive. She has to arrive and has to be subjected to what this court has held. She properly found that Ms. Maughan had demonstrated the attacks which have taken against her, and that the attacks are ongoing and have escalated and are designed to intimidate and harass her. And as Ms. Maughan explained, every time she appears in court as a litigant, these attacks intensify, as was evident during the hearing of the interdict application. So we're not dealing here with just appearance. We're dealing with appearance coupled with the kinds of abuse that no one should have to put up with if the summons was unlawfully issued to start with, and that is what this court has rightly held. So of course sometimes criminal accused have to appear and take abuse, and that's unfortunate and terrible and all the rest, but here we're dealing with someone who is going to be subjected to that, where the summons has already been held to be unlawful, and no court has disagreed with this court yet. Maybe someone will one day. We say there's no chance, but no court has set it aside. The third element of harm is Ms. Maughan's freedom of expression as a journalist, because this court held correctly that if Ms. Maughan's allegations have to be accepted, which had to be because there was no bona fide dispute of fact, then, quote, she has demonstrated that Mr. Zuma's private prosecution has been instituted for the sole purpose of silencing her. And as Ms. Maughan explained in the interdict proceedings, the prosecution seeks to achieve that by bullying her into silence and causing her considerable distress and anxiety that has diverted her attention from her professional work. Now, our learned friend's answer to that is to say, well, she keeps on reporting, so she's obviously fine. With great respect, the fact that Ms. Maughan has soldiered on and has done her job to the best of her ability despite these extraordinary challenges is not a reason to say that there is no danger or risk to freedom of expression. On the contrary, it is a testimony to her courage, and that should be applauded. So there are three harms to Ms. Maughan, personally: to her right to freedom of movement and liberty, to her safety and security and dignity, and to her freedom of expression. Those are not just rights, those are constitutional rights. And they are all more than amply justify a Section 18(3) order. But it goes further to the fourth point, and that's the point we make at page 17. And that is that the ongoing enforcement of Mr. Zuma's unlawful summons, before this court's order has been set aside, would cause irreparable harm to the administration of justice. Because unless this court grants an interim execution order, it will unwittingly enable and facilitate, and most importantly, be seen by the public to enable and facilitate the ongoing abuse of its own process. And that is extraordinarily damaging to the public interest and to the administration of justice. Now, there used to be a debate about whether Section 18 could be used where it was the public that would suffer rather than the individual litigant. But that point was put to bed by the Interim decision. It's referred to in the heads repeatedly, but the passage I wish to read to the court is at paragraph 47. Because what had happened in Interim is that Mr. Interim had been appointed as the head of the Hawks, and that decision had been reviewed and set aside at the instance of the Helen Suzman Foundation. And the question was, should the court grant an interim order of execution pending appeal by Mr. Interim? And the court did. It granted an 18(3) order, And on appeal, the SCA unanimously and emphatically upheld that. And at paragraph 47, it said as follows, Justice Navsa speaking, insofar as the requirements of section 18.3 are concerned, the High Court cannot be faulted for its approach to the question of irreparable harm to General Ntlemeza. On the other side of the coin, it found there was no irreparable harm. On the other side of the coin, there is the public interest and the critical place that the DPCI, that's the Hawks, enjoys in our young democracy as set out above. In my view, the High Court cannot be criticized for concluding that HSF and PUL had proved on a balance of probabilities that the public will suffer irreparable harm if the court does not grant the order, and that General Ntlemeza will not suffer irreparable harm in light thereof. So that is clear authority for the proposition that even where the only harm, and I use the word only in inverted commas, even where the only harm is to the public interest, that is enough for an 18.3 order. Now in this case, of course, it's not the only harm. It is the fourth category of harm we've specified, but it is by itself enough. For this court to say, this process initiated by Mr. Zuma was an abuse. It is an abuse for an ulterior purpose, and yet we will allow the court to be used for that ulterior purpose, even before our judgment has been set aside on appeal. It would make an ass of the law. It would say that judges' time and courtroom time and legal fees can be used to go through a farce because we know that this is unlawful. Now, of course, the game changes if one day, somehow, Mr. Zuma persuades an appeal court to disagree with this court and set aside the main order. But until that happens, how can it be seriously contemplated that this court should allow its processes to be abused when this court has found that that abuse is present? So there are four categories of harm that would be suffered unless a Section 18.3 order is granted. That's on the one side of the scale. Now we go to the other side of the scale, and that's my third point. What is the harm to Mr. Zuma if the 18.3 order is granted? Now, there's much said about Mr. Downer and this and his removal. That's been dealt with by my learned friend, and I'm not getting into it because none of it has any relevance to Ms. Maughan. So I'm focusing on Ms. Maughan. What is the harm that will be caused to Mr. Zuma if Ms. Maughan is not, if Ms. Maughan does not have to go through her criminal attendances and trials unless and until a court sets aside, an appeal court sets aside this court's main judgment? What is the harm? And the answer is there is none. Not one iota of harm. Because the most that is said is, well, if Ms. Maughan doesn't, if Mr. Zuma doesn't attend, then his criminal prosecution will be dismissed. But as I've explained, that is a nonsense. Because if this court makes an order within immediate execution on an interim basis, there is no criminal proceeding. There is no need for anybody to attend. And the world will move on. And if at the end of the day Mr. Zuma succeeds in his main appeal, everything will be restored and everything can proceed. So that point about harm is patently bad as a matter of law and as a matter of logic. So the most that we get is that there will be a delay, that instead of starting on the 4th of August or the 10th of August or the 30th of August, Mr. Zuma's prosecution of Ms. Maughan will not start then. It will only start at the end of the day when in this theoretical world, when the appeal court sets aside this court's main decision. Well, with respect, that is no prejudice at all, because how can it be seriously contended that the prosecution should take place, the trial should be heard, Ms. Maughan should be subject to acquittal or conviction in circumstances where the whole thing has already been set aside? And of course, we've made the point in the heads that even the timing of the prosecution against Ms. Maughan raises serious questions about delay, because Mr. Zuma was incredibly dilatory in pursuing the private prosecution. He only instituted it in September 2022, more than a year after the publication of the letter. That is common cause on these papers. So the idea that this is going to extinguish the prosecution is patently bad. The idea that there will be delay such to give rise to irreparable harm is patently bad, because remember, it's irreparable harm we're debating, not any form of harm. And beyond that, I ask, what has Mr. Zuma put up by way of harm if an 18.3 order is granted? And the answer is nothing. So on one side, we have the 4 species of harm we've demonstrated. On the other side, we have nothing. Well, then a Section 18 order is to be granted. That leaves only 2 points. The first is prospects of success, and the second is the question of remedy. Now, of urgency. Now, on prospects of success, in Mr. Zuma's heads of argument, the assertion is made at page 7, paragraph 18. And I'll read it. It says, second point in limine, failure to plead or establish prospects of success. Although admittedly not mentioned in Section 18, it is now well established by the SCA that an applicant bears the additional burden to establish on a balance of probabilities that he or she has reasonable prospects of success on appeal. There are no authorities cited there. Not one. Despite the fact that in our heads we made the point that that proposition was without any legal foundation and said we couldn't find law for it. So that's the first problem. It's not enough to say it's well established. You've got to put up authority. But we looked for some authority. And the most that we could come up with, and we presume that this is what's intended to be relied on, but as I will demonstrate, it doesn't support the argument at all. The most that we could come up with is the decision of the SCA in University of the Free State versus AfriForum. That's 2018, volume 3, essay 428, at paragraphs 14 to 50. Could I read that, given that so much is made of prospects of success? Because there what happened is as follows. It says, a question that arises in the context of an application under Section 18 is whether the prospects of success in the pending appeal should play a role in the analysis. And then there's a reference to 2 Joburg cases which held that prospects of success were irrelevant. And then it says, however, in Justice Alliance, Binns Ward J was of a different view, namely that the prospects of success in an appeal remain a relevant factor, and therefore the less sanguine, I must confess I had to actually look up sanguine, it means optimistic. The less sanguine, optimistic, a court seized of an application under Section 18.3 is, about the prospects of a judgment being upheld, the less inclined it will be to grant the exceptional remedy of execution of the judgment pending appeal. And then the court says, I'm in agreement with the approach of Justice Binns Ward. And then there's a debate about whether the full record was before the court, etc. So that is a very different proposition from what is advanced here. The proposition that is advanced in paragraph 18 is that the applicants for an 18.3 order have some sort of onus or duty to establish, or burden to establish on a balance of probabilities that they've got reasonable prospects of success. But with respect, that makes no sense. Obviously, we've got reasonable prospects of success. We persuaded these 3 judges. Now, that doesn't mean this judgment is correct necessarily, but how could it ever be said that we don't have reasonable prospects of success on appeal? We persuaded these 3 judges. No other judges disagreed. So this proposition with yet, I'm happy with the yet. No other judges disagreed yet. So have we got reasonable prospects of success? Of course we have. The correct proposition is a completely different one. And there's no onus. It's not a pleading point. The correct proposition is the one from paragraph 14, Judge Binns Ward. The less sanguine, optimistic, a court seized of an application is about the prospects of success of the judgment at first instance, the less inclined it will be to grant the exceptional remedy of execution. Now, I accept that proposition. I accept it because the SCA says I accept it, says I must accept it. So what that means is if this court is sitting and this court is thinking, sure, we really got this one wrong. I wish we could go back and do it again, but it's res judicata and we got this wrong. If that's what this court is saying, then this court will not be optimistic or sanguine about the prospects of success of it being upheld, and it will incline against it. It's not a jurisdictional fact, it's not a pleading point, but it will weigh in this court's mind. But of course the converse is equally true. The more optimistic and the more sanguine this court is, if this court says or thinks, even on a prima facie view, if it thinks on a prima facie as it must, of course we were right. And this subsidiarity point that is dredged up in an effort to show we were wrong is complete nonsense. If that's what this court thinks, then that weighs in our favor, not against. So we don't run away from prospects of success. We're happy to embrace it. My learned friend for Mr. Down has argued it in detail. We've got nothing to add except to say he's right. But there is no prospect in the world, and I make this submission seriously, there is no prospect in the world that this court's order in respect of Ms. Maughan is going to be overturned. Maybe, theoretically, some court is going to find that this court shouldn't have upheld all 3 grounds. They should only have upheld 2, or upheld 1. But we only need 1 to win. It's the order that you appeal against, not the reasons. Is there any prospect in the world that an appellate court is going to say the certificate of nolle prosequi was properly issued against Ms. Maughan, that there was an interest sufficient to justify under Section 7, and that there was no abuse? I make the submission, and I make it deliberately and seriously. There is no prospect in the world. And what that means is that prospects of success weighs in favor of Ms. Maughan, not against her. I'm not going to say anything more about prospects of success. So now, lastly, on the question of urgency, our learned friends want to have some debate about urgency. We've addressed urgency in the heads, in the papers. I will simply refer you to what we say in the papers. And what we say is this. We say that the immediate urgency does arise from the appearance on the 4th of August. We ask for an order before 4 August. Because if this court grants an 18-3 order before 4 August, then Ms. Maughan will be excused from appearing, and that is what we ask for. No, says our learned friend, but then they will appeal immediately. Well, let me make the first point. That is contemptuous. It is contemptuous to say to a court, I will appeal no matter what your reasons. I will appeal no matter what your order. If it's adverse to me, I will appeal. It is contemptuous. And it is indicative of the continued Stalingrad approach, and it is indicative of the abusive process. We've said this expressly in the affidavit. I say it again. It is contemptuous for any litigant to say to a court, I'm not even going to bother to read your judgment. If you're against me, I'm appealing. It is contemptuous. But even if it were not contemptuous, even if it were somehow permissible, it is irrelevant. Because this court has to make the order it chooses to make. And this court should make an order which, if it stands, will prevent the appearance on the 4th of August. The fact that Mr. Zuma might in a contemptuous or otherwise manner appeal is deeply unfortunate, but it doesn't change the order that this court should make, and it certainly doesn't deprive us of urgency. But even if you left all of that aside, let me assume that somehow you could accept that Mr. Zuma is definitely going to appeal, and that will mean we've got to appear on the 4th of August. Just let me assume all of that in Mr. Zuma's favor. It still doesn't change the urgency, because it's not just what happens on the 4th of August. It's what happens on the 4th of September. We don't know at this point what Mr. Zuma is going to do on the 4th of August. We're now told there'll be a request for postponement. We're not told how long. We're not told when the trial is due to proceed. And with respect, given the twists and turns that have taken place in this matter, you can have no faith in anything you are told about what may or may not happen on the 4th of August. You, with respect, as the bench hearing this case today, have to deal with 2 things. A certainty that if you don't make an order, there will be an appearance on the 4th of August. And a certainty that if you make an order and set aside the criminal summons, there is nothing to appear about on the 4th of August. Those are the 2 certainties. And that means that this matter is self-evidently urgent. But even if there were any doubt on that score, and there isn't, we have referred you to the very helpful decision of the Labour Court, which makes clear that these matters are inherently urgent. That is the judgment in Trendy Greenies, which is a fabulous name for a company, Trendy Greenies versus De Bruyn, where the court said that urgency should be dealt with on the basis that the Superior Courts Act, quote, treats the enforceability of a judgment pending appeal processes to be inherently urgent. It's inherently urgent, and for obvious reasons. So in our respectful submission, the case for the relief sought is amply made out. That leaves only the question of costs. We ask for costs, and we ask for them on a punitive basis, because we tried to avoid this by writing the letter requesting the undertaking. We wrote the letter, that's in the papers. We wrote the letter and said, look, if you will agree that things are put on hold, and a joint approach can be made to the criminal judge to say, let's just deal with this and put it on hold, that would have resolved the need for this application. Now, our learned friend says in his heads, well, that would have been an unlawful request. On what possible basis? Parties do it all the time. All the time. They say, let's reach an agreed position pending appeal. We'll approach the judge to get it approved, and that's the end of it. But of course, we get back a flat no. So the only reason we are here with all of these counsel and 3 judges convened is because of an unreasonable refusal to accept that proposal. And so we say that we are entitled to the costs of 2 counsel on an attorney-client scale, and we would ask for that. My lord and my ladies, those are our submissions. Yes.
May I ask you a question?
Certainly.
In terms of section 18.4,
Yes.
automatic appeal process, how does that work? Do you have to file an appeal, or does it just flow naturally, irrespective of the scope of
No. So the way it works, and I've had the misfortune of being involved in a couple of them, is that you don't have to seek...
I'm asking the right person.
Yes, indeed. You don't have to seek leave to appeal, but you do have to file a notice of appeal. So it basically bypasses the leave requirement, but you still file the notice. And so in practical terms, what that means is, if this court were to be with us and to grant an order, then Mr. Zuma would have to file a notice of appeal in the SCA, because that's the next highest court, and then the SCA is required to deal with it as a matter of extreme urgency. It's the one-liner, essentially. Thank you. Thank you, my lord.
What would you want to take the short adjournment now? Give you some more time to gather your thoughts?
My lord, maybe if your lordship could indulge me until 11, just so that I outline the arguments, and then if we take the break, then we'll go into the...
Because I'm aware, and history has shown that once you're in your stride, it's hard to stop you.
Well, not that your lordship did not try hard. Yeah. But I appreciate that, my lord. My lord, well then, if I'll ask just for this bonus few minutes here. And we'll only start the clock after the break. My lord, on a more serious note, I just want to I think it would be important that when we take the break, we would have outlined what this case actually is about and not about, and why this. I'm prepared to put a wager with Mr. Badlander Jr. that I've done more Section 18 cases than him by 4 or 10-fold. But
you're suggesting that the procedure that he explained to me is incorrect?
18.4, yes. Yeah, no, in fact, that question was pertinent. That question that you asked, my lord, on the merits actually kills the entire case. So I'm appreciative that your lordship raised it, but we'll come to that. Our argument is that one doesn't even have to go to the merits. Now, I say this to you, my ladies and my lord. Honestly speaking, of all the Section 18 cases I've ever done, this is one that should literally take 5 minutes and 5 minutes only, including from the question that your lordship asked, because that kills the case.
Are you suggesting you'll be 5 minutes?
Yes. If the court is, that's why I wanted the court not to take the break, because it might be a permanent break. Firstly, we say that this matter, there are 2 legs to it. The first leg is what we call the points in limine. And they are important. My learned friend, Mr. Badlander, did not even bother to talk about the first point in limine, which is urgency. My learned friend, Mr. Badlander Stephen, spoke about the first and also said something about the second, which is the issue of prospects of success. Now, that's all that you really need to deal with in this case. But in the likely event that you want to entertain the merits, we'll also deal with the merits. And it might well be, by the way, on the principle of something called S versus Jordan, that this court would have to deal with that anyway, because it helps the appeal court in case the appeal court finds that our points in limine are not good enough. Then otherwise the appeal court would then have to bring it back here. So from a practical point of view, accept that even if you agree with us, you might have to deal with the merits. But I can assure you that we will simply deal with the merits when we come back after the tea break, simply for that purpose. But this case is about the first 2 points. Now, Mr. Stephen Badlander says that we've gathered counsel here, we've flown and all that, and 3 judges, and he's right. Why? Why are we here on a Friday? 5 days or 4 court days before the next court appearance, which is next Friday, which means this is super urgent. Well, I'll show you that the urgency is non-existent and contrived. This matter is about one thing and one thing only. Forget all the bluster. It is about to try and prevent the appearance next week. That's it. It is about to try and ensure that the appearance on the 4th of August in particular does not take place. And I will show you, my lords and my ladies, and my lord, that actually that is where the case should end, because there is no conceivable way of preventing the appearance next week. There isn't. So whether you grant the order, you don't grant the order, or whatever you do, the appearance next Friday is going to happen. And I'll demonstrate why that is so. So then what are we doing here? We're just, whiling away time. Because the appearance of, that is the gist of what we're here about, is unpreventable. So that's the first thing. The second thing is that Mr. Badlander tells us that, and it's tied to the question that your lordship asked again, in terms of the 18.4 principle. Remember that Mr. Zuma has told this court candidly that on his assessment of the judgment, and of course, Mr. Badlander was to tell the judges that no other judges in this country can find differently from you. Well, I have news for him. Actually, it's exactly what is going to happen, and I'll deal with that when the prospects of success discussion takes place. But for now, all I want to say is that in terms of 18.4, if this court grants its judgment, let's say on Monday, I'm being overly optimistic, or in 2 weeks' time, or whatever it is, whatever actually, even now at 12. Mr. Zuma tells the court candidly that he is going to file the notice of appeal, and Mr. Stephen Badlander is quite correct that is a step that has to be taken. But as we know, these days, notice of appeal, you can do it in 2 minutes, because it's no longer the old detailed thing. Now, what will then happen? Let me be overly optimistic. I don't want to impose overtime on your lordships, on your ladyship and your lordship. But let's be optimistic and say on Monday your judgment comes, and on Tuesday or even on Monday, Mr. Zuma files his notice of appeal. Section 18.4 tells us what will then happen. The status quo ante will be restored. Right? What is the status quo ante? The status quo ante is the situation as it was on the 6th of June this year. Because your judgment came on the 7th of June. So when we say the status quo ante, we mean exactly the situation that was there on the 6th of June. And that, in terms of 18.4 Roman 4, means that the judgment is suspended, exactly where we are right now. So it's a merry-go-round which is intended to serve no purpose whatsoever. I'm now talking about if you grant I'm going to show you that you cannot grant this order, but I'm arguing against myself. I'm assuming that the court will grant the execution order. It's futile on that basis, let alone what I will show you later, that it should not be granted. So on the best case scenario for them, there is no urgency which attaches to the appearance of the 4th. Now, Mr. Stephen Budlander, surreptitiously, maybe not intentionally, then postulates what might happen after the 4th. Now that's completely wrong, because it then goes exactly to what we're saying. Why must this court preempt what must happen after the 4th? Because the court on the 4th is going to determine what must happen. This court has no right to dictate to that court on the 4th to say that this or that must happen. The court on the 4th, at least from experience, having been in this matter for some time in these different phases, both the criminal private prosecution and this one. What's likely to happen on the 4th is very simple. There's nobody in their right mind, least of all myself or Mr. Masuku, who's going to say that we're going to come here on the 4th and say, Judge, we've got our first witness ready. No, that court will be seized by the reality that there is a judgment, it is being appealed, and it must then deal with the matter according to those. That happens, that's what happens all the time, not what Mr. Stephen Budlander says happens all the time. I have a practical example of a matter the court might know about, this matter which involved the wife of a minister, where we went to the High Court and received an order to do with unlawful arrest and what have you, and which obviously affected the prosecution. But what then happened is that after that, once we got that judgment, it was a judgment of His Lordship Mr. Justice Sardiwala, we then went to the criminal court, as we should, and said to the court, we won in the High Court, and therefore could you provisionally withdraw the charges? And that's what happens. But if I were like my learned friends, I would have said to my client, oh well, we won, you can go on holiday now. You don't have to go and appear in the criminal court and explain that you have won. We should have been arrested. Should have had to be arrested, because the court had warned her, you must come on such and such a date, I can't remember now. And then she doesn't pitch. Why? No, because she won in the High Court. What is that? Everybody, every judge, every magistrate knows that what should happen is that you then come to that court as you have been warned, and you say, whatever has happened, the accused has died or whatever, I don't know, the witnesses have all left the country, whatever. But this is then the implication. So it's not for this court, but for the court on the 4th. Now, the court on the 4th might say, as it did in February, we will give a long postponement for 5 months. Remember, the 4th of August, the postponement happened on the 2nd of February. So it was a 5-month postponement. So we can assume that the court is capable of giving another 5 or 6 months postponement. And if it does that, or the court might even give a postponement sine die, and I'll show that this is also possible. Now, if that court gives a 5-month postponement or gives a postponement sine die, then where's the urgency? Because it means this application could have been heard in September, October, November, or December even. So why are we here now in urgent court on a Friday for a matter that could be heard in October? Because the next appearance could be in January next year. So forget that other obfuscation. This thing is just about the 4th of August, which is next week. And so that's the first point. The second point is what we call the prospects of success. And I would suggest then that we take the break, but let me just introduce that point. On the prospects of success, my learned this case also dies completely. Well, it should die from the agency, but assume that somehow this court finds that it's urgent. The prospects of success, let me put this very, very plainly. There are, in Section 18 applications these days, there are 4 requirements. Mr. Jeff Butlander is quite right. 4 requirements. And those 4 requirements are 3 plus 1. What do I mean by that? It's the 3 statutory requirements plus 1, which is prospects of success. The one of prospects of success, I call it a judicial requirement because it was introduced after the statute by the judiciary. But that's just a historical fact. The reality is that, as Mr. Jeff Butlander said, there are 4 requirements. And if one of those 4 requirements is not pleaded and established, then the order cannot be granted. And then there's an argument that says, no, it's not an onus. No, well, that's probably right. It's not an onus. It's actually a heavy onus. That's what the SCA has said. That the party wanting to get this exceptional remedy must discharge a heavy onus. Now, if the onus-bearing party, if there are 4 requirements for anything, I mean, this is Law 101, there are 4 requirements, and the onus-bearing party pleads 2 of them. What must happen? Then they must lose. If the onus-bearing party pleads 3 of them, what must happen? The onus-bearing party must lose. If it pleads all 4, then what must then happen is that they must prove, and whatever the scale is, here it's a balance of probabilities. But our task in that respect is very easy. I will show you after tea that actually, as far as Mr. Downer is concerned, he has not pleaded prospects of success at all. In fact, he has not even mentioned them in his founding affidavit.
Take the tea, Judge.
If I can just...
So both of you
Yes.
asked me for 5 minutes, you've taken 15 already. I hope this is not going to set the trend for the rest of the day.
No.
Thank you. We will adjourn.